One of the quickest ways I've seen lawyers lose cases is in jury selections. And quite frankly, it can be humorous. For example, consider the average person, unpolluted, before they go to law school. Well, they walk with everybody else, they talk like everybody else, and they pretty much think like everybody else. But a strange thing happens in law school. It sharpens your mind like a pencil. And what do I mean? To a point. Well, that creates problems. It actually gives attorneys a handicap, most of them, to where they never can really relate to a jury. They're further polluted by the fact that as soon as they get out of law school, they're thrust of commercial publications that tell you exactly how to pick a lawyer. And I remember what my father told me when I came home. I was a young prosecutor, and we were talking about selecting a jury one night. I brought home one of the books. I was very impressed with it at the time. And I asked him, I said, well, what do you think about it? He took the book and he said, well, Charles, he says, I'll tell you what. He says, take a look at this book. Every book that you've read like this has a problem with it, a problem with selecting the jury. And I thought, what in the world are you talking about? He said, well, right here. He says, it's right here on the cover. He says, look at the cover of this book and read it. The problem is right on the front of it. It's not that it's not a good book to read. You should read these books. But there's something that you're missing if you don't understand the cover of this book before you even open it. So I'm sitting there reading every word of it thinking, I don't get it. And he looks at me and he finally says, Charles, the problem with this is that it's written by lawyers. He said, the first thing I want you to do when you go back to Ocala, is find a day where you don't have a jury trial. And I want you to simply walk the hallways when the jurors are taking breaks during selection. Wander into the bathroom, wash your hands, listen to what they are saying. He said that will be a good supplement to these books because it will get you back in the real world. I did that. I was absolutely amazed at what I heard in the hallways. I would hear statements like the farmer saying, I don't know what dang bit of difference it makes what bumper sticker I've got on my car. I'd hear other people saying, I don't know what difference it makes if I'm over 55 years old. I don't know what could possibly have anything to do with what television programs I watch. And then I would hear the comment, this is just some little retail theft case. That son of a bitch has had us up there for 2.5 hours asking us these stupid questions. And all of a sudden, the point was driven home. I went back and I immediately resolved and did change the way that I select a jury. And it starts with asking yourself, are you going to have respect for these people or not? Because if you don't, it's going to show. And I've heard it in the hallways. So I know exactly how that works. That's why my method, Charles Alleman's method of selecting a jury, is not the same as a lot of these other people. I've tried over 300 cases, jury trials. And I can tell you in all those jury trials, this really didn't dawn on me and I really didn't appreciate it until I'd had over approximately 150 jury trials when I saw this actually work. Lawyers go into a jury assuming, apparently, that the people are stupid. Well, they aren't. And the problem with that is simply this. They're going to think the lawyer is being abusive and disrespectful. I can't think of a better way to lose a case right off the bat. What are we doing when we select a jury? We're trying to really determine whether or not the individual jurors have a conflict of interest, whether there's something in their personal life that is so heavy that it might influence them in passing upon the guilt of the defendant and utilizing the standard of guilty only when proven beyond and to the exclusion of every single reasonable doubt. What's wrong with telling a jury what you're looking for right off the bat? What's wrong with telling a jury, asking them, this is what I'm going to do. This is why I'm asking these questions. And then you turn and you say, for example, how many of you have relatives that have been in law enforcement or close friends? And you'll have a number of people that will raise their hands. Now, why would I ask that question? And I will always use the term, look, I don't want to be sneaky Pete on you at all, because I don't. The reason I'm asking you these questions is there something that's tugging at your heartstrings? Is it somebody that you room with? Is it a very close friend? Is it someone that will question you after this verdict? Is it someone that will think lesser of you if your verdict is one way or the other? Then I turn to the court reporter and I say, look, the court reporter takes an oath. They take an oath to accurately transcribe everything that they hear. Well, what if that court reporter doesn't like what she hears? So she types something else. What would you think about that, juror number one? And of course, they're going to tell you they wouldn't like it. There's the judge sitting up there. Well, it's no secret as to why he sits high. That comes from traditional standards. It's just like Moses coming down from the mountain. He's going to give you what the law is in this case. And while it's not going to be on a tablet, the law remains fixed, and the jury's not allowed to change that. It's no excuse that you sit second highest in the courtroom, because what you're going to do is you're going to try to determine the facts of this case, and the judge will not mess with the facts of this case. And so you understand your respective roles. What about attorneys whispering? One of the things that's written about, and you hear a lot about it on television, is when attorneys go to the bench and they whisper. Well, what the devil is the jury thinking? Well, I'll tell you what they're thinking. They're thinking we've got something to hide. What's the best way to get around that? The truth. Let's try that for a change. Juror number 3, why do you think we're going to the bench and whispering? Lots of times they'll stall and they'll hesitate. And you're like, I know, you're uncomfortable with the real answer. Tell me what you really feel. And they'll tell you, well, we think you don't want us. We don't want to be heard. You don't want to be heard by us. You're absolutely right. And why is that? Because we are at the bench debating questions of law. And questions of law are none of your concern. And indeed, that is because the judge will give you what the law is at the conclusion of this trial. And if you hear a debate like that, it can result in confusion, and it can result in injections of issues that may very well hamper you in your fact-finding process. And that's why we do that. You are absolutely right. We don't want you to hear, and guess what? You're not even supposed to try to hear. Now, that sounds incredibly unfair, doesn't it? Well, let me ask you this. How fair would it be when you went back there and deliberated if all of us, including the judge, had our ear to the door? You don't want that to be heard either. What's wrong with telling a jury that right up front? It's honest, it's candid, and it's not a sneaky Pete way of trying to find out things and patting yourself on the back for your own ingenuity and saying, I've done a great job, when really all you've done is made a jury angry.